So we will begin now with 20 minutes argument for each side in our first case, Dye versus Esurance Property and Casualty.
May I proceed? Good morning, Chief Judge. Good morning, Justices. My name is Robert Logeman. I represent the estate of Matthew Dye. The case is a fairly, and I'd like to reserve about 5 minutes for any questions or rebuttal that may occur. It's a very simple case. It's a father who bought insurance for his son who owns a car. And the defendant in their brief at 2 points, both in the facts and in the argument, say, well, everybody knows that when you buy insurance, that if you're buying insurance, you're the named insured. Well, in 44 years of meeting people that had auto accidents and representing, it's amazing how few people have an appreciation. The father in this case made a statement when he was asked, well, why didn't you put the insurance in your son's name? And his response was, and I think I quoted it in the brief, was, I thought I was buying insurance on a car. And that's what people do. They have an obligation, they know they have to buy insurance, and they go out and they buy a policy. One of the cases that recently came out, a published case from the Court of Appeals, was where the husband bought the insurance for the family, for him and his wife. His wife owned a car, he owned a car, and the wife was catastrophically injured. I mean, the medical bills were about $1.5 million, at least according to that record. And because the wife was the owner of the car, she was precluded by the argument in this case from recovering no-fault benefits. The problem is that in no-fault, we are insuring people, not cars. We've said that since Lee versus DAIIE, the Michigan Supreme Court, that we've kind of taken a view that we look to a family unit to provide the coverages. We essentially buy a health and disability policy for our people, the people we know or the people we're acquainted with. And I think the statute, and I've faced this issue twice. I faced this issue back in 2011 in the Beaudet case that Judge Wilder was a panel member, where the mom who didn't live with the son, adult owned the car, and had an accident, and the question was, did he have no-fault coverage? And in that case, they said, Insurable, a Court of Appeals case, was correctly decided on this particular statutory provision that the statute excludes coverage when the vehicle doesn't have the required security. Not that you have to be the owner of the vehicle has to have the required security. And that was the holding in Insurable. That was the holding in Beaudet at that time. But Beaudet wasn't published. And so when Barnes came out 3 years later, it distinguished Insurable and simply said the others were not precedent, and said that Insurable was a case where there was an owner who had insurance on the car. And a lot of this goes back to the question of who has to buy the insurance. The defendant in their brief made a reference to insurable interest, that you had to have an insurable interest. Well, and I briefed it a little bit because I frankly didn't think it applied, and I wrote about 4 pages of the brief on it. Insurable interest, historically, going back to 1871, the Supreme Court talked about insurable interest, and you can't have a wager contract. Well, a wager contract means, hey, I'm going to put some money on an insurance policy, and if it burns or whatnot, I'm going to make money on the deal. The next case was actually a fire case, Crossman, about 50 years later, about 1917, which was a fire case, and someone bought an insurance policy, fire loss, but he had an option to buy. And the question was, did he have an insurable interest? Well, the concept of insurable interest really goes to whether you have a property interest that you're going to profit from if something wrong happens. That doesn't apply to health insurance, to disability insurance. You are trying to protect against a loss that's going to occur personally to you. And I think that the insurable interest concept simply doesn't apply to an auto insurance policy except in one very limited way. In one limited way, if I bought the insurance on my daughter's car and put it under our family policy, I bought her health insurance, I bought her disability insurance, and frankly, it won't even matter whether her car's involved in most cases. She's going to get it if she's the pedestrian walking out to the parking lot. She's going to get it from the cars that we've insured. But when I do that, there's one segment of an auto policy that maybe has a property component, and that's the collision coverage. That if I don't own the car, I probably can't be the one to cash in on the collision portion of the damage to the car if it's totaled. That would be the owner's. But that's the only segment of the no-fault law and the no-fault policy that you're buying that really has any component of what you would call a property interest or an insurable interest argument. The statute that we're trying to deal with is statute 3113B that says a person was the owner or registrant of a motor vehicle or motorcycle involved in the accident with respect to which the security required by section 3101 or 3103 was not in effect. That phrase, respect to which security required by section 3101 or 3103, by the last antecedent construction rules, focuses on the motorcycle or the motor vehicle, not the owner, which is what Barnes did. I think Esurance and Baudet properly said, hey, under this exclusion, if there is an exclusion, it's only where the vehicle doesn't have the insurance that's required. In this case, and in a lot of these family cases, they do have the insurance. There are other unpublished cases in the Court of Appeals since Barnes that have dealt with, for example, you had a father of a son who was living with a woman and he wanted to help them out, and he put the insurance on the woman's car. She died in the accident. The question was she entitled to coverage? They had the coverage. They participated in the no-fault system. They contributed to the plan, and it's more of a pot than a pool than it is anything else. And so as a practical matter, they've done what they're supposed to do. They contributed to the no-fault system in paying their insurance, whether it's this car, that car. They participated in the plan, and they're entitled to the no-fault coverage. One of the amicus briefs that was filed late in this matter was the assigned claims, and they said, well, gee, you shouldn't, these people are getting insurance on uninsured car. Well, first of all, it's an insured car. You're just assuming that it's not insured because the person who was one of the owners was not the named insured. But secondly, the assigned claims 3171 takes an assignment, just an allotment from every insurer for the funding of cars that they're putting in on the road. And it isn't because they're bad people or they didn't buy insurance, but because they're senior citizens that don't have insurance and hit by a car, or anybody who you can't identify who it is.
Mr. Logeman?
Yes.
Obviously, this case will ultimately be resolved on the basis of the language of the insurance code.
Yes.
But tell me why a responsible system of insurance would arguably obfuscate and confuse the nature of the risk undertaken by the insurance company by not making clear to the insurance company who is it precisely that's being insured, who's driving precisely is being insured in a particular instance.
Well, first of all, there's a couple of cases that follow Barnes where the actual son or daughter is the listed driver. I mean, that's pretty clear who the risk is being associated with. And in most cases, the insurance companies don't go and take a poll of every person and what their driving record is. And the point of that is that you have equipped the insurers with the basis that if they want to challenge that this is someone who shouldn't have got insurance, that there was a kid with a bad record, there was a child who's getting insurance in an area where the parent lives because it's a cheaper rate, it's a rated area cheaper. Those kind of things under your Titan case and the Bozzi case would allow them to challenge on a basis of fraud that they failed to disclose someone with a bad driving record.
Counsel, good morning and welcome to our new term. Let me ask you a question just to follow up with the Chief's question. Wouldn't it be fair to say that the essence of no fault, which is in its namesake, which is no fault, goes to the argument of the risk? Isn't the essence of isn't the whole idea of no fault going to its namesake, that no fault is, quote unquote, no fault, correct? Which is the exchange that was made in order to allow for a no fault system. You're not going to assess risk.
That's true. And I think that the fact that you're buying insurance, for example, it doesn't matter whether I was at fault in the accident or not, whether they owe no fault benefits.
But isn't that the name is no fault, correct?
That's right. Yeah, yes. And so as a practical matter, you'd say, well, what they were buying was a health and disability insurance irrespective of fault in the accident. But more to ask your question on actuarial fraud, et cetera, that I think that you have equipped the insurers with a basis to challenge based on claim that misrepresentation or fraud to avoid a policy where such a situation exists. And it didn't in this case. I mean, there's no argument that he had a bad record. He lived in Adrian, about 7 blocks from his dad, or 10 blocks, some short distance. So it's not like this is any kind of an area or anything that anybody has said dealing with fraud. And in most of the cases that you'll see under Barnes, they don't talk about fraud. They don't talk about a bad record. It's simply, hey, he wasn't a named insured. And people just simply don't appreciate that they have to be, quote, a named insured on a car in which they're an owner. They understand that they have to be buying an insurance policy for a car because no fault requires them to do that.
Hasn't that been the tradition, that people have always assumed that under no fault that the policy goes with the car and not with the person? Isn't that the whole essence and tradition of how no fault has been established and implemented?
Oh, yeah. I mean, back 40 years, they'd come in and say, I had full coverage. And I could always say, my goodness, I know for sure that means your car had collision coverage. But as far as what other coverages they have, many people have no concept of what insurance coverages are available. And particularly, and this child-family dynamic is more common now than it was 40 years ago. That now we have more adult children living in the house. We have more adult children getting support by family members, and whether it's just paying the insurance premium on to make sure the kid doesn't miss a bill payment. But it's a much more common problem, I think, than it ever was, and people don't appreciate it. 3101 simply says you got to maintain insurance on the vehicle, the owner or registrant. And I'm just saying that when a parent buys the insurance policy, the kid has maintained the insurance. He doesn't have to be the named insured. He just has to have insurance on the car so he doesn't get in trouble. And he's done so. So I think under the law that the argument that you are defrauding the insurance company, if they wanted to raise the fraud argument, they could have raised it. If they wanted to argue that this was a misrepresentation and they could try to get out of the policy that way, they could have done so. But the question and the argument here is, do we contort the statute, which says simply that the car has to have the insurance? And in fact, the focus of no fault is that we don't worry about whether the particular car is insurance. You get it from your own home or you get it from the other insurers. If that concept is being met by the people all buying a policy under no fault for their car, they've contributed to the system, they've honored the system, and they've done what they're supposed to do. The mere fact that they weren't a named insured, there's nowhere in the statute that says that specifically. Do you have any other questions of me?
Well, you have 5 minutes to go afterwards.
Thank you. Well, maybe you'll think.
Thank you, Mr. Logman.
Good morning, Your Honors. Drew Broadus for Defendant Appellee Geico. Plan to waive the fire-free period after just a couple of brief remarks. The first, I want to emphasize I'm here for Geico, not Esurance. And the reason that's important is the policy that Mr. Paul Dye bought was from Esurance, not Geico. So a number of the arguments have been raised in terms of his idea of what was going to be covered by that policy don't really pertain to Geico. Geico was the insurer of Mr. Dye's wife. And the other point that I want to talk about that is...
Could you please raise your microphone just a little bit in front of you?
No problem. Is that better?
There's a switch underneath there that you'll see.
On the microphone?
No.
Moves the whole podium up.
It's a very confounding switch. There's no question about it.
So I wanted to mention that arrangement because if you look at the deck pages for the GEICO and the insurance and the Esurance policies, he's not a named insured under either one, nor is his, and the vehicle is not listed on the GEICO policy at any point. So what happened here is we have a situation where Matthew Dye got into the system without any opportunity for either insurer to rate that risk. And I understand Justice Bernstein's question about being a no-fault scheme. I'll get into that later. But I just want to emphasize that we were not the ones that issued the policy for this vehicle to Paul Dye. It was Esurance. The other thing I want to mention, the insurable interest argument, that's kind of a red herring. I don't recall discussing that in any detail in my brief. I think that was an issue that one of the amicus kind of interjected. And I agree, this isn't an insurable interest scenario. Insurable interest, if a policy is purchased without an insurable interest, it's void. We're not saying this policy is void. There are still situations where it could apply and where someone other than an owner injured in their own vehicle could obtain no-fault benefits.
Counsel, I understand you didn't issue the policy. Oh, yellow light's still on. I'm sorry. Keep talking. Did you waive?
Okay, I'm prepared to waive now, yes.
All right. Sorry. Thank you. I understand you didn't issue the initial policy and Esurance did, but is it your understanding that is there some claim of fraud on the part of the plaintiff in the background in this case? Do you believe that?
No, and it's not. It's not because, for one, it's extremely difficult to prove fraud. So it's not an angle that we want to take if we can avoid it, and the statute doesn't require it. And the notion that, and I want to address this, isn't directly relevant to your question, but it sort of is, the suggestion that we can fall back on rescission as a remedy for this, I think is a really bad argument because under Bozzi, in this case, if this were a Bozzi scenario, Matthew Dye would have an innocent third-party argument where, because he didn't buy the policy, he never interacted with either insurer, or under the balancing of the equities, that's not going to cut our way a great deal at the time, quite frankly. Or if it is, we're still learning the contours of that. So for us to fall back on that, I just don't think that's consistent with the scheme, and it doesn't put us in a fair position. There's a great many times where we're not going to be getting a premium that reflects the risk, and we're not going to be able to rescind the policy even if there was a misrepresentation.
Why don't you consider the radical response of having an additional line on your form asking the insured whether he or she is also the owner or registrant?
I understand that. That's why I wanted to emphasize that would be an argument for Esurance to respond to. They were the ones that issued this policy to Paul Dye for a vehicle that apparently he didn't own or may not have owned. That's the fact question that would be resolved. So that's a good idea.
Anytime I can help.
I don't know that pertains to GEICO in this case, but also the person buying the policy is in the best position to say if they have an ownership interest in the vehicle. And we do have to wonder, why are people, what is the reason for buying insurance on vehicles that you don't own or use frequently enough to be a constructive owner? So it does come down to who's in the best position to make sure the information is accurate.
Well, who under the statute is required to have the security?
The owner or registrant under MCL 500.311. I'm sorry, MCL 500.
Plaintiff's father was a registrant, correct?
No, he was not. Court of Appeals definitively said he wasn't. The trial court found that he was under this odd theory that because Paul went to the Secretary of State under a power of attorney and signed it himself and then put power of attorney for Matthew Dye, the trial court said, well, that made Paul a registrant. And the Court of Appeals said, no, it doesn't work that way because you're acting on behalf of Matthew when he stepped into the office. So no, if Paul was a registrant, it'd be a very different case. Trial court found that he was, in addition to being a constructive owner.
Plaintiff's father was a registrant, correct?
No, plaintiff's father was not a registrant of the 1997 BMW. That was a finding by the trial court that the Court of Appeals rejected and said, no, he's not a registrant.
Well, who was the registrant?
Matthew, because his father, Paul, signed it pursuant to a power of attorney that Matthew had given him. So Paul's signature appears on the registration. The Court of Appeals addressed this very briefly in the unpublished case that's appealed from here. But Matthew was the registrant.
And the registrant is required to maintain security on the vehicle.
Owner or registrant, right. So there's a couple different people that can satisfy this, like in the Iqbal case, you had co-ownership situation. One or the other, or both, preferably both. But, right, if Paul had been a truly registrant and not signing it on behalf of his son under a power of attorney, they'd have a case that, yeah, this satisfies the statute and does not distinguish Iqbal. But that wasn't the scenario here. He signed it as Matthew.
Any further? Okay. Thank
so-
you. Oh, I'm sorry.
Is that satisfied? I just wanted to make that clear because it was an odd argument. I found it very odd in the trial court. Court of Appeals didn't say a whole lot about it, but they did reject that proposition. So really, this begins and ends with the statute. The last antecedent rule was suggested as being relevant to this, and I think that it makes some sense so far as it goes, but it really just gains ground for the plaintiff that's not disputed. You look at 3113 subpart B. Yes, it refers back to the motor vehicle, but what's required there? What does a motor vehicle have to have under 3113B? It has to have the security required by Section 3101. So ultimately, all the last antecedent rule does is tell us that the vehicle needs to comply with 3101, which in turn, that's where you get to the person, because 3101 says the owner or registrant is the one that shall maintain, and that's a mandatory, that's a shall. And this court mentioned in Citizens.
But it says shall maintain, it doesn't say shall purchase.
Right.
Shall be a named insured. It simply says shall maintain. I mean, really, isn't that the meat of this question here?
Yeah, it is. I think that's the toughest part of our argument is we have to turn the corner and say shall maintain means he's got to be a named insured under the policy. But I'd like to point out Citizens versus Federated Mutual, this case, this court in 1995, 444 MISH 225, specifically said the No-Fault Act requires the owner or registrant of the motor vehicle to purchase the policy. It was a different context factually, but it was the same subpart that the court was dealing with there. And so I'll fall back on what we talked about in my brief beginning at page 20, which is we have to have some objective way of saying, what are you doing to maintain it? Maintain requires some affirmative act. I think we all agree on that. You have to do something. And plaintiff suggests, well, if you're paying your dad back under the table for the premiums, which was also the fact pattern in Barnes, you're doing something to maintain. And I submit that it's not, because we have to have some way objectively to say, what are you doing to maintain insurance on the policy? And the only way to do that definitively is to be a named insured, to eliminate the possibility of the risk not being reflected properly.
But why does there even have to be evidence of paying under the table? If I say to my teenage son, I want you to maintain the lawn this summer, I'm not paying him anything.
No.
It's his job. Cut the lawn.
He's doing
Is the lawn not being maintained?
By you?
Yeah, it's my house.
I would submit it's not, because you're asking him to maintain it. He's the one that's got to maintain it. He's the one that's got to take an affirmative act. So and here's the
Yet if
problem.
I hired an independent contractor and paid him, then I would be maintaining?
Yeah, you're doing something affirmative that we can objectively point to. There's a contract there. And the problem with all of this.
His affirmative was telling his son to go
That
to the
is
lawn.
my affirmative act.
And here's the problem with that, and that's the gist of Matt's argument here, Matt Dye's argument. That would require us to assume the legislature meant for the eligibility under 3101 and 3113B to hinge on these undocumented arrangements between family members and friends that are extremely hard to pin down. You're basically inviting a situation where every case like this is going to require discovery to even get past the threshold question of whether.
But if the premium is paid, why would the legislature care?
Because
the whole idea is to obtain insurance, pay for the premium, so that everybody's covered.
Well, there's got to be an opportunity to allocate and manage the risk of the person that's got ultimate control of the vehicle. And this court has said that in Twitchell, that this whole scheme hinges on ultimate control of the vehicle. So if we have someone that's not using it regularly, it doesn't satisfy constructive ownership. Constructive ownership is the concept that lurks in the background here that makes this actually work in a vast majority of cases, I think, is because most of the situations, most of the parade of horribles that Mr. Logeman referenced in his brief are going to be.
I guess I'm having a hard time between construction ownership and actual ownership, because Matthew is indeed the actual ownership under the registration.
Right, Matthew.
Yeah.
Matthew, not the one, but Matthew didn't buy any policy.
And the only question is whether Matthew's maintaining insurance when his father pays for it.
Right. And I submit he doesn't, because he's not named in any policy. He never interacted with anyone from either insurer in this case. There's testimony to that effect. He never placed the call. He never went online and started punching in info. He never did anything except for had a conversation with his father, which is extremely hard to, for one, like I said in the beginning, no insurer ever had a chance to look at Matthew Dye as a potential risk and say what premium associates with that. And I'm not saying it's a fraud situation. We're not saying he's uninsurable. But where you live matters to that, your record. there's a number of things that go into that no insurer ever had a chance to evaluate. So that's the key to why I think the Barnes panel correctly made the connection that you're looking for me to make now is maintain does require you to be the named insured because anything else
Doesn't that go to the whole question of no fault?
Well, it does. No fault. I mean, no fault refers to we're not going to get into who caused the accident. You're going to be compensated whether you caused it or whether you didn't cause it. It doesn't say we don't care about risk. And there's a number of cases that talk about the fact that in order for that system to work, the private insurers that manage it and allocate the funds have to be able to collect premiums that accurately reflect what they're undertaking.
You don't think you're trying to get the best of both worlds here? You're operating under a no-fault system, but then you still want to assign fault. It just seems to me that goes against. I mean, if you just want to be a pure tort state, that would be a distinction versus what we have in no fault. Like, it just seems like you're trying to have both.
Well, no, my argument doesn't have anything to do with who's responsible for the accident. My argument is looking prospectively before the accident, the insurers that manage the system that's responsible for everybody that pays in for lifetime benefits has to be able to say, okay, this person maybe has a perfect record, but they live here and there. And
you've already conceded to the Chief Justice that you probably wish Esurance had asked those questions at the front end, right? I mean,
sure.
That information was findable. I have a lot of teenagers, and 3 of them are boys, so I've bought a lot of car insurance policies in the last few years. And Esurance, I swear, I think I bought it like in 10 minutes online, and they asked me very few questions. I now have a policy with State Farm. I think they took fingerprints of all of us, so I'm exaggerating, but it was the most robust process, you know. So all of those questions are questions the insurance company can ask at the front end
right.
to decide how to price its contract, right? And it just didn't here. Is that the bottom line?
Well, as far as we know, I mean, I don't represent Esurance, so we have limited information in the record about what.
But therefore, you need us to do the robust work that Justice Zara was asking about, right? For this
I'm asking.
work for you.
I don't know that it's robust work, but yes.
Yeah.
The short answer is yes.
It has to mean a lot. Yeah.
But I don't think any other system allows the legislative intent to operate of 3101 and 3113B, and it's too vague otherwise. If we have these situations like we have here where we get a year into the case and we take discovery and find out, he meant for me to, that was supposed to be my policy, but it wasn't listed anywhere, and you get this stuff years down the road that information we're supposed to be having up front, and you're right, we could ask for it. If that's something, but the question becomes, are we obligated? What's the positive law that we have to ask those questions on the front end? There isn't one at this point.
If we rule in your way, what happens if the next case, Frank's got a horrible driving record and Matthew's got a perfect record? Does Matthew get coverage because you assessed the risk for Frank, who's probably shouldn't be driving, but you insured him anyhow, and Matthew had the perfect record, had no accident?
If the facts were analogous, if you're saying this is a situation where the only insurer is Frank.
We don't have much information either way.
Okay.
But you say, well, we weren't able to assess. We don't know. But what if the facts turned out that Frank was just a horrible driver, had enough money to pay for his insurance, and find someone to insure him, and Matthew was the perfect driver?
If Matthew's injured in his own vehicle, he needs to be the one taking out insurance on it.
So that really doesn't matter to you. The assessment of the risk really doesn't matter to you.
It's
all about the language of the statute, and that's it.
Yeah, I would submit it. Whether it matters to me, I submit it secondary to whether it matters under plain language. So yes, in that scenario, we would have actually, Frank would have paid in, and Matthew should have had his own policy in that scenario. And if it's his vehicle, I want to emphasize this is a fairly narrow fact pattern where someone is kicked out. You have to be injured while an occupant of your own vehicle. And if there's any other co-owner of that vehicle and they are named insured on a policy, you're still good. I'm not challenging the Iqbal ruling that the brother who bought no insurance on his own car still gets pipped because the other brother that's a co-owner wasn't named insured. So the situations, but they do come up. When they come up like here, it's I think a fairly serious issue that we have Matthew Dye never assessed by either carrier.
So help me with the language of MCL 531.13b, where the legislature chose to limit non-entitlement to benefits to whom insurance is, quote unquote, not in effect.
Because it refers back in the first sentence, they're not entitled to PIP unless, the paraphrase there. And then you go down to B, they're the owner or registrant of a vehicle involved in the accident with respect to the security required by 3101, and that's the hook. You go down to 3101. If the policy that they have required by 3101 is not in effect. So if there's
But that takes it back then to shall maintain.
Right.
We have to understand what shall maintain means,
I agree, yeah. All roads lead back
whether
to shall
I'm paying
maintain.
my son to cut the lawn or not.
Yeah, and if it's just a conversation that you had and that's all we're dealing with, and, you know, I think this, for the legislative intent to be carried out, we can't rely on those vagaries of side deals and conversations that are unrecorded.
How would you define maintain?
Buying a policy of insurance and putting yourself as the named insured.
So if I look in the dictionary and look up the word maintain, that's what it'll say?
Well, you have to do something, and that's more than Matthew did here for sure. Matthew didn't really do anything except talk to his dad about the idea that he was going to buy some policy sometime. So
I'm going back to the cutting the lawn. My local ordinance says that I shall maintain my lawn and not allow it to get longer than 4 inches in length. And then I have my son cut it every week when it's at 3 inches at length. Am I maintaining my lawn?
your son cuts it, and this comes to the ordinance, it's still not, I'm sorry, your son cuts it for you, it's not still too high?
Right,
So you get in trouble for it?
right. Would the city not say I'm maintaining my lawn? Or would they say, no, it's your home, but somebody else was cutting them and you weren't paying for it, so you weren't maintaining your home?
It could be a problem, yeah. If your idea is your son's supposed to do that for you and he doesn't do it in compliance, and here I guess
That's right. If
analog,
Frank didn't pay for the insurance, there's been no insurance maintained on this vehicle. But Frank did pay for it.
I think the analog here would be, and the testimony supports us in this case, that if Paul had gone and bought that policy and listed Matthew as a named insured, then that would be the analog to what you're describing, and then Matthew would have maintained. Because we have an objective way of saying he is making sure his vehicle is insured. And these are the kind of nuances that I think the No-Fault Act is supposed to not have to worry about. That's why it was understood by Barnes and several panels that followed it without reservation, unpublished cases, just assumed that, yeah, you got to be the named insured to maintain.
I think this case is a bit more straightforward than you're suggesting. The statute says that security shall be maintained. I think the better and more relevant interpretation of maintained is to preserve from failure, to preserve from a lapse. There was security here, there was insurance, hence there was no failure to preserve it. It was preserved, there was insurance. What more needs to be understood about this case?
Matthew didn't do anything, the owner or registrant.
We don't know whether he did anything or not. He may have asked his father, he may not have, but the fact is it was preserved either through action or inaction. What does the legislature seem to care?
Well, they care because...
What does the dictionary seem to care in terms of maintain?
Because that act of preventing the lapse, maintaining, keeping in place, has to be done by an owner or registrant. And we looked at Matthew's testimony here.
It doesn't say that in terms of maintain. It's all it says is that the security shall be maintained. Insurance shall be maintained. It was maintained here. Through affirmative action or otherwise, it was maintained.
In 3101, 311B may lend something to that argument that it's okay as long as it's maintained, but 3101 specifically says that the owner or registrant shall maintain.
I don't see that language.
In 3101, the cross-reference from 311B pushes us down to say, yeah, the vehicle is okay if the security is maintained, but it's got to be the security required by.
Well, I agree. The insurer or the owner or the registrant needs to maintain the security, but I'm saying the security has been maintained here either through the owners or through someone else's action. It doesn't seem to make any difference under this statute who it is, how the maintaining is done.
I disagree because 3101 specifically says the act has to be by an owner or registrant.
Okay, I understand your argument.
And I think some of the confusion may be between the cross-reference here that may be explicitly not in 3113B, but the first sentence of 3101 subpart 1 says the owner or registrant.
Counsel,
That's who has to do something.
I'd like to get an answer to Justice Zara's question because I thought it was a really good question, and I'm really uncertain as to your answer. Has he maintained his lawn under the scenario that he gave where his son was asked to do it and his son was mowing the lawn and the lawn is under the 4 inches? Has Justice Zara maintained his lawn?
Well, if it's under the 4 inches, then I guess it's kind of a philosophical question. I mean, I would submit no under the language of if it's analogous to this language. I would
I
submit
don't
he
want you
hasn't.
defending me then when the city issues me a ticket.
Well, I may be more likely to represent the city in that scenario.
How is he, I don't understand, help me to understand, how is he not, the lawn is quote unquote maintained. The lawn is under the statutory limit. So his son has been mowing the lawn. The lawn is at the length that is permitted. How is it not maintained?
Well, and I think the first thing I want to point out about that hypothetical, if the lawn's actually okay.
I'm sorry?
No,
I just
it's never going
couldn't
to come to anyone's attention, just like if the case here was Matthew had been named as the insured on a policy that he had nothing to do with, but his dad got for him, we wouldn't have this conversation. So that's where it breaks down. But I still submit, if the ordinance that's in question in your scenario pins the responsibility specifically to the homeowner, then yes, he hasn't maintained. I'm sorry.
Homeowners shall maintain their lawn at less than 4 inches.
Well, again, if it's under 4
My
inches.
neighbor doesn't.
If it's a philosophical question at that point, because no one's ever going to come to you and say your lawn is compliant with the ordinance, but we don't think you're doing it. Just like you hear, if he was a named insured, we wouldn't say we don't think you did anything to get the policy, but because it's a tough question.
Right.
But
it's going to the meaning of maintain.
it is go to the meaning and
The
maintain.
ordinary, normal use of how we use the word maintain.
Right, but it's got to be read in the context of the first part of that sentence. It's who's got to do the maintaining, the owner or
The
registered.
homeowner in our city shall maintain their lawn at less than 4 inches.
The homeowner's got to do it, right? And the homeowner's the one. If the son doesn't,
Then I'm in trouble.
then you're in trouble. And here,
But here the son did.
well, did he though? I mean, what did he do beyond your scenario? Is having a conversation is
Okay.
enough. I don't think it is. I don't think the purposes of the act can be furthered if these informal, unwritten discussions between friends and family cut the muster.
Thank you, Mr. Broadus. Appreciate it. Mr. Logeman, you have 5 minutes to go.
Just a few things to comment about and any questions you might have. I smiled a little bit when we were talking about lawns and maintenance because as a teenager, I had the job of cutting my lawn. And the week after I went away to college, my father bought a riding lawnmower. And it's kind of like, the maintenance is still being done, but it's being done differently now. But in answer to your question, Justice Viviano, the definitions that I included in my brief were that maintain means to continuing, keep in effect, cause or remain unabated, or preserve. Those are the kind of some of the definitions with the term maintain. What I would ask this court is not to change or divert 3113B. It says that the motor vehicle has to have the required insurance. And if it does, it meets the requirements. What I'd ask in your relief is that the no-fault exclusion of 3113B does not bar an owner from no-fault coverage if there is an insurance policy on the vehicle. That would cover the disabled lady in Barnes who couldn't drive a car anymore, and so she gave money to her friend to buy insurance and to drive her to church 2 times a week. Technically, that friend probably was an owner as a constructive owner under the statute, but in the lower court, they've been summaried out as an owner, and therefore he wasn't an owner on appeal. But clearly, that person who was still the title owner was doing what he had to do to keep the insurance, to maintain that insurance in effect on the vehicle. The case where you have the father of the son who was living with a lady who was killed in an accident and he puts insurance on her car, that's helping financially somebody. Is there any doubt in my mind if I told my daughter I paid your auto insurance for the year, that if somebody were asked her, are you maintaining insurance on the car? She'd say yes, because that's what we do, and that's what we're doing as a family. And that's what I think the state of Michigan and this statute allows. Unless you have any further questions of me?
Thank you, Mr. Logeman.
Thank you.
Thank you both.